Philippine Criminology Licensure Examination. Subject: Correctional Administration. Question number 1. A penologist argues that punishment serves as a warning to the rest of society not to commit crimes. Which theory of punishment is being applied? A. Retributive theory. B. Reformative theory. C. Deterrence theory. D. Incapacitation theory. Correct answer: C. Deterrence theory. Why C is correct? The deterrence theory holds that the primary purpose of punishment is to discourage or prevent future criminal behavior, both in the offender, specific deterrence, and in society at large, general deterrence. When punishment is used as a warning to others, this is the classic concept of general deterrence, which aims to dissuade the general public from committing crimes by making an example of the punished individual. Why the others are wrong? A retributive theory. This theory focuses on an eye for an eye. Punishment is justified as a proportional response to the wrong committed, not as a warning to others. It is backward-looking, not forward-looking. B. Reformative theory. This theory focuses on rehabilitating the offender so they can re-enter society as a law-abiding citizen. The goal is internal change in the criminal, not warning others. D. Incapacitation theory. This theory justifies punishment by removing the offender from society, e.g., through imprisonment, to physically prevent them from committing further crimes. It does not address warning the public. Edge knowledge. Keyword is warning to the rest of society equals general deterrence equals deterrence theory. If the question says warn others or example to others, always go with deterrence. Question number 2. Under the Revised Penal Code of the Philippines, which of the following penalties is classified as an afflictive penalty? A. Arresto mayor. B. Prisión correccional. C. Reclusion perpetua. D. Destierro. Correct answer: C. Reclusion perpetua. Why C is correct? Under Article 25 of the Revised Penal Code, RPC, penalties are classified according to their severity. Afflictive penalties are the most severe and include reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison mayor. Reclusion perpetua, which carries imprisonment of at least 20 years and 1 day up to 40 years, as modified, is clearly classified as an afflictive penalty. Why the others are wrong? A. Arresto mayor. This is a correctional penalty, covering imprisonment from 1 month and 1 day to 6 months. It is among the least severe penalties under the RPC. B. Prisión correccional, also a correctional penalty, ranging from 6 months and 1 day to 6 years. Despite correctional in its name, it is not an afflictive penalty. D. Destierro. This is also a correctional penalty that involves banishment and prohibition from entering a certain area. It is not an afflictive penalty. Edge knowledge. Memorize the hierarchy. Afflictive to correctional to light. Anything with reclusion or mayor, for prison, is afflictive. Correccional, arresto, and destierro are correctional or light. Question number 3. The Bureau of Corrections, BuCor, is under the supervision and control of which government department? A. Department of Interior and Local Government, DILG. B. Department of Social Welfare and Development, DSWD. C. Department of Justice, DOJ. D. Office of the President. Correct answer: C. Department of Justice, DOJ. Why C is correct? The Bureau of Corrections, BuCor, is an agency under the Department of Justice, DOJ, as provided under Republic Act No. 10575, the Bureau of Corrections Act of 2013. BuCor is responsible for the rehabilitation, safekeeping, and institutionalization of national prisoners, those sentenced to more than 3 years of imprisonment. Why the others are wrong? A. DILG. The DILG supervises the Bureau of Jail Management and Penology, BJMP, which manages city and municipal jails for detainees and those sentenced to 3 years or less. BJMP and BuCor are distinct agencies. BDSWD. The DSWD handles social welfare programs, including care for children in conflict with the law, CICL, through Bahay Pag-asa. It does not supervise national penitentiaries. D. Office of the President. The BuCor does not report directly to the Office of the President in its day-to-day operations. Only the DOJ has direct administrative supervision over BuCor. Edge knowledge. BuCor to DOJ, BJMP to DILG. This pairing is one of the most frequently tested facts in the Criminology board exam. Memorize it as a pair. Question number 4. Inmate Pedro, sentenced to reclusion temporal, has been consistently displaying good behavior inside the National Penitentiary. Under the Good Conduct Time Allowance, GCTA, law, RA 10592, which government body has the authority to grant GCTA to Pedro? A. Board of Pardons and Parole, BPP, B. The court that imposed the sentence. C. The Superintendent of the Penitentiary. D. The Director General of BuCor. Correct answer. C. The Superintendent of the Penitentiary. Why C is correct? Under Republic Act No. 10592, which amended Articles 97 to 99 of the Revised Penal Code, the authority to grant, restore, or forfeit good conduct time allowance, GCTA, lies with the Director of the Bureau of Corrections, for national prisoners, or in practical application, delegated through the superintendent of the facility. The GCTA is an administrative matter handled by the prison administration, not by courts or the BPP. The superintendent, as the head of the penitentiary, directly oversees the recommendation and implementation of GCTA credits. Why the others are wrong? A Board of Pardons and Parole, BPP. The BPP deals with parole and conditional pardon applications. It does not administer GCTA, which is an internal prison administrative function. B. The court that imposed the sentence. Courts impose sentences but do not monitor day-to-day prison behavior or administer time allowances. GCTA is administrative, not judicial. D. The Director General of BuCor. While the Director General has overall authority over BuCor, the operational grant of GCTA is delegated to and implemented at the facility level by the superintendent. The Director General's role is supervisory, not the direct grantor at the ground level. Edge knowledge. GCTA equals prison administration function. The superintendent, at the facility level, handles it. Whenever a question asks who grants GCTA, look for the prison facility administrator. Question number 5. Which of the following best describes the concept of parole in the Philippine correctional system? A. The conditional release of a prisoner before the expiration of his maximum sentence after serving the minimum penalty. B. The release of a prisoner after full service of sentence. C. The suspension of sentence execution granted by the President. D. A form of community service imposed by the court instead of imprisonment. Correct answer. A. The conditional release of a prisoner before the expiration of his maximum sentence after serving the minimum penalty. Why A is correct? Parole under Indeterminate Sentence Law, Act No. 4103, is the conditional release of a prisoner who has served the minimum period of an indeterminate sentence, subject to conditions set by the Board of Pardons and Parole, BPP. The parolee is released before completing the maximum sentence but remains under supervision. Violation of conditions results in re-incarceration. Why the others are wrong? B. Release after full service of sentence. This describes an absolute discharge, not parole. Parole is specifically a conditional, early release, not release after full sentence completion. C. Suspension of sentence execution granted by the President. This describes a reprieve or one form of executive clemency, not parole. The President grants reprieves, commutations, and pardons, not parole, which is granted by the BPP, D. Community service instead of imprisonment. This describes community service as an alternative penalty under RA 11362, not parole. Parole involves a prisoner who has already been incarcerated. Edge knowledge. Parole equals conditional plus early plus before maximum sentence expires plus BPP grants it. Associate parole with the indeterminate sentence law and the BPP. Question number 6. The Philadelphia system of prison discipline, also known as the separate system, is characterized by which of the following? A. Prisoners work together during the day and are separated only at night. B. Prisoners are kept in complete isolation at all times, even during work. C. Prisoners are classified according to their sentence and housed in separate buildings. D. Prisoners are given vocational training to prepare them for reintegration. Correct answer. B. Prisoners are kept in complete isolation at all times, even during work. Why B is correct. The Philadelphia system, separate system, which originated in the Walnut Street Jail and later the Eastern State Penitentiary in Pennsylvania, circa 1790 to 1829, was based on the Quaker philosophy that total solitary confinement would encourage inmates to reflect on their sins and reform. Prisoners were kept in complete isolation, eating, working, and sleeping in their cells, with no contact with other prisoners. The goal was penitence, hence the word penitentiary. Why the others are wrong. A work together during the day, separated at night. This describes the Auburn system, congregate system, developed in Auburn, New York. It allowed silent group labor during the day and solitary confinement at night. C. Classification by sentence in separate buildings. This describes a modern classification system used in contemporary correctional management, not the historical Philadelphia system. D. Vocational training for reintegration. This is a characteristic of modern rehabilitation-oriented prison programs, not the Philadelphia system, which was punitive and isolationist in nature. Edge knowledge. Philadelphia equals separate equals total isolation. Auburn equals congregate equals silent labor by day, isolation by night. These two systems are always paired in board exam questions. The keyword for Philadelphia is total isolation. Question number 7. Inmate Maria is sentenced to imprisonment of 2 years and 4 months by the municipal trial court. To which facility should Maria be committed? A national penitentiary under BuCor. B. Provincial jail under the provincial government. C. City or municipal jail under BJMP. D. Rehabilitation center under DSWD. Correct answer. C. City or municipal jail under BJMP. Why C is correct. Under Republic Act No. 6975 and RA 9263, the Bureau of Jail Management and Penology, BJMP, has jurisdiction over city and municipal jails and houses inmates sentenced to a term of imprisonment of 3 years or less, prisión correccional and below. Since Maria's sentence is 2 years and 4 months, clearly below 3 years, she falls under BJMP jurisdiction. Why the others are wrong. A national penitentiary under BuCor. BuCor handles inmates sentenced to more than 3 years, i.e., prison mayor and above. Maria's sentence does not meet this threshold. B. Provincial jail under the provincial government. Provincial jails are under the local government and generally hold prisoners with sentences between 6 months and 3 years in provinces without BJMP facilities. However, in areas with BJMP-operated jails, BJMP has primary jurisdiction. In standard board exam context, BJMP is the correct answer for sentences of 3 years or less. DSWD Rehabilitation Center. DSWD handles children in conflict with the law, CICL, through Bahay Pag-asa. Maria, presumably an adult, does not qualify for DSWD commitment. Edge knowledge. 3 years or less equals BJMP. More than 3 years equals BuCor. This threshold is the single most tested jurisdictional rule in correctional administration. Question number 8. Which of the following best describes recidivism as a concept in correctional administration? A. The commission of a crime for the first time. B. The tendency of a convicted offender to reoffend after release. C. The transfer of an inmate from one prison to another. D. The act of granting early release to a prisoner based on good behavior. Correct answer. B. The tendency of a convicted offender to reoffend after release. Why B is correct. Recidivism is defined as the repetition of criminal behavior by a person who has previously been convicted and sentenced. In correctional administration, the recidivism rate is a key indicator used to measure the effectiveness of rehabilitation programs. A high recidivism rate suggests that the correctional system has failed in its rehabilitative mission. Why the others are wrong. A commission of a crime for the first time. This describes a first-time offender, not recidivism. Recidivism specifically involves repeat offending after a prior conviction. C. Transfer of an inmate from one prison to another. This is called prison transfer or inmate relocation, an administrative correctional function. It has no relation to recidivism. D. Early release based on good behavior. This describes parole or the operation of GCTA, good conduct time allowance. It is a release mechanism, not a behavioral pattern associated with recidivism. Edge knowledge. Recidivism equals repeat offending after conviction. The keyword is again or after release. If the question mentions re-offending or returning to crime, the answer is recidivism. Question number 9. The power of the President to reduce a prison sentence without fully absolving the offender of the conviction is known as A. Absolute pardon. B. Conditional pardon. C. Commutation of sentence. D. Reprieve. Correct answer. C. Commutation of sentence. Why C is correct. Commutation of sentence is a form of executive clemency under Article 7, Section 19 of the 1987 Philippine Constitution, wherein the President reduces the penalty imposed by the court, such as reducing a death sentence to life imprisonment, or reducing the length of imprisonment, without erasing the conviction itself. The offender remains convicted, only the punishment is reduced. Why the others are wrong. A. Absolute pardon. Absolute pardon fully restores all civil and political rights and wipes away the effects of the conviction entirely. It does more than just reduce the sentence, it extinguishes the conviction's consequences. B. Conditional pardon. Conditional pardon releases the offender from punishment but imposes conditions. If the conditions are violated, the offender may be re-incarcerated. It is not specifically about reducing the sentence. D. Reprieve. A reprieve is a temporary postponement of the execution of a sentence, most commonly associated with postponing a death sentence. It does not reduce or modify the sentence itself, it only delays its execution. Edge knowledge. Commutation equals cut, reduce the sentence. Associate commute with shortening a trip, journey. Similarly, commutation shortens the sentence. No erasure of conviction, just reduction. Question number 10. Under the Indeterminate Sentence Law, Act No. 4103, which of the following offenders is exempt from its application? A. An offender convicted of homicide. B. An offender convicted of estafa. C. An offender convicted of treason. D. An offender convicted of theft with a sentence of 3 years. Correct answer. C. An offender convicted of treason. Why C is correct. Act No. 4103, Indeterminate Sentence Law, expressly exempts certain offenders from its coverage. Under Section 2 of the law, the following are not covered. 1. Those convicted of offenses punished with death penalty or life imprisonment. 2. Those convicted of treason, conspiracy or proposal to commit treason. 3. Those convicted of misprision of treason, rebellion, sedition, or espionage. 4. Piracy. 5. Those who are habitual delinquents. 6. Those who escaped from confinement. 7. Those who violated the terms of conditional pardon. 8. Those whose maximum term of imprisonment does not exceed 1 year. Why the others are wrong. A homicide. Homicide carries a penalty within a determinable range, reclusion temporal, and no specific ISL exemption applies to it. The ISL would apply. B. Estafa. Estafa, swindling, is a property crime where the sentence depends on the amount involved. As long as the maximum exceeds 1 year and the offense is not among the exempt crimes, the ISL applies. D. Theft with a 3-year sentence. a sentence of 3 years exceeds the 1-year threshold for ISL exemption. Since theft is not among the specifically exempted offenses, the ISL would apply. Edge knowledge. Memorize the ISL exemption list using the acronym TMESH-P. Treason, misprision of treason, escape from prison, sedition, rebellion, habitual delinquents, piracy. Treason tops the list, easiest to remember. Question number 11. Which of the following is not a recognized form of executive clemency under the 1987 Philippine Constitution? A. Reprieve. B. Amnesty. C. Probation. D. Commutation of Sentence. Correct answer. C. Probation. Why C is correct? Article 7, Section 19 of the 1987 Philippine Constitution grants the President the power to grant reprieves, commutations, pardons, absolute and conditional, and amnesty, with concurrence of Congress. Probation is not a form of executive clemency. Probation is a judicial and administrative mechanism under Presidential Decree No. 968, Probation Law of 1976, granted by the trial court, not by the President. It allows an offender to remain in the community under supervision instead of serving a prison term. Why the others are wrong? A reprieve, a valid form of executive clemency. It temporarily postpones the execution of a sentence and is specifically mentioned in the Constitution. B. Amnesty, a valid form of executive clemency. It is granted by the President with the concurrence of a majority of all the members of Congress, and it extinguishes criminal liability for political offenses. D. Commutation of sentence, a valid form of executive clemency that reduces the severity of the penalty. It is expressly provided in the Constitution. Edge knowledge. Probation equals court action, not presidential clemency. Whenever probation appears in a list of clemency forms, it is the odd one out. The 4 forms of clemency are pardon, reprieve, commutation, amnesty. Question number 12. An inmate in a national penitentiary is assigned to work in the prison farm, learns carpentry skills, and participates in values formation seminars. Which correctional philosophy is primarily being applied? A. Retribution. B. Rehabilitation. C. Deterrence. D. Incapacitation. Correct answer. B. Rehabilitation. Why B is correct? The scenario describes multiple components of a rehabilitation program: agricultural work, prison farm, vocational skills training, carpentry, and values formation. Rehabilitation is the correctional philosophy that aims to reform the offender and prepare them for successful reintegration into society as a productive, law-abiding citizen. It is the foundational philosophy of modern correctional administration in the Philippines. Why the others are wrong? A. Retribution. Retribution focuses on punishing the offender proportionally to the crime committed, an eye for an eye approach. It does not involve skills training or values formation. C. Deterrence. Deterrence uses the threat or experience of punishment to discourage criminal behavior. Work programs and values formation are not tools of deterrence but of positive behavioral change. D. Incapacitation. Incapacitation focuses on physically removing the offender from society to prevent further crimes, e.g., imprisonment, restraint. It does not address the offender's inner reform or skill development. Edge knowledge. Skills training plus values formation plus work programs equals rehabilitation. Any scenario describing productive activities aimed at changing the offender equals rehabilitation. This is the most human-centered approach. Question number 13. Which of the following international instruments specifically provides minimum standards for the treatment of prisoners? A. Universal Declaration of Human Rights, UDHR. B. United Nations Standard Minimum Rules for the Treatment of Prisoners, Nelson Mandela Rules. C. International Covenant on Civil and Political Rights, ICCPR. D. Convention Against Torture, CAT. Correct answer. B. United Nations Standard Minimum Rules for the Treatment of Prisoners, Nelson Mandela Rules. Why B is correct? The UN Standard Minimum Rules for the Treatment of Prisoners, formally updated and renamed the Nelson Mandela Rules in 2015 by the UN General Assembly, Resolution 7175, is the specific international instrument that provides detailed standards for the treatment of prisoners. It covers accommodation, hygiene, medical services, discipline, information rights, and safeguards against torture and ill treatment. It is the primary global standard for prison management and prisoner rights. Why the others are wrong. AUDHR, the Universal Declaration of Human Rights, 1948, is a broad, foundational human rights document. While it includes provisions against torture and arbitrary detention, it does not specifically address prison management and minimum treatment standards in operational detail. C. ICCPR, the International Covenant on Civil and Political Rights, is a binding treaty covering civil liberties broadly. Article 10 mentions humane treatment of persons deprived of liberty, but it is not the specific instrument for minimum standards of prisoner treatment. DCAT, the Convention Against Torture, is specifically focused on prohibition of torture and cruel treatment. While relevant to correctional settings, it does not provide comprehensive minimum standards for prison management and operations. Edge knowledge. Minimum standards plus prisoners equals Nelson Mandela Rules, formerly UNSMR. The renaming to Nelson Mandela Rules in 2015 is a favorite board exam fact. Associate his name with prisoner rights. Question number 14. Probation in the Philippines may be granted to an offender whose sentence does not exceed A. 1 year, B. 6 years, C. 3 years, D. 4 years. Correct answer, B. 6 years. Why B is correct? Under Presidential Decree No. 968, Probation Law of 1976, as amended by RA 10707, probation may be granted to a convicted offender sentenced to a term not exceeding 6 years of imprisonment. The application for probation must be filed by the offender within the period for perfecting an appeal, 15 days from promulgation of judgment. If an appeal is filed, the right to probation is generally waived, with amendments allowing some exceptions under RA 10707. Why the others are wrong. A. 1 year. This was an old threshold under earlier jurisprudence but is not the current legal standard under PD 968 as amended. The threshold of 1 year would be too restrictive. C. 3 years. This is the jurisdictional threshold for BJMP, sentences of 3 years or less, not the probation eligibility threshold. Confusing these two thresholds is a common exam mistake. D. 4 years. There is no legal basis for a 4-year probation threshold in Philippine law. This is a distractor designed to test memorization accuracy. Edge knowledge. Probation equals 6 years or less. Don't confuse with BJMP's 3-year threshold. A simple memory trick. 6 for probation, 3 for BJMP. Question number 15. Which of the following is the primary purpose of classification in a correctional institution? A. To identify inmates suitable for early release. B. To separate inmates based on the severity of their crimes for security purposes. C. To properly assign inmates to programs and housing based on individual needs and risks. D. To determine the amount of good conduct time allowance an inmate may receive. Correct answer. C. To properly assign inmates to programs and housing based on individual needs and risks. Why C is correct. Classification in correctional administration is a systematic process of assessing and categorizing inmates to determine appropriate housing, supervision level, program placement, and services based on their individual security risk, needs, and rehabilitation potential. The primary goal is to match the inmate to the right environment and program, not merely to segregate for punishment or determine release eligibility. Modern classification uses validated assessment tools, e.g., risk and needs assessment instruments. Why the others are wrong. A. To identify inmates for early release. This is the function of parole evaluation and review conducted by the Board of Pardons and Parole, not the classification process within prison. B. To separate based on crime severity for security. While security is one factor in classification, is too narrow a description of the primary purpose. Classification is a holistic process that goes beyond security segregation to address individual program needs and rehabilitation pathways. D. To determine GCTA. GCTA is determined through monitoring of behavior and compliance with rules over time, which is a separate administrative function. Classification at the point of intake does not determine GCTA. Edge knowledge. Classification equals assessment for proper assignment, housing plus programs plus supervision. It is individualized and holistic, not just security-based separation. Question number 16. In the Philippine Correctional System, which agency is responsible for supervising parolees and pardonees in the community? A. Bureau of Jail Management and Penology, BJMP, B. Parole and Probation Administration, PPA, C. Board of Pardons and Parole, BPP, D. Bureau of Corrections, BuCor. Correct answer. B. Parole and Probation Administration, PPA. Why B is correct. The Parole and Probation Administration, PPA, under the Department of Justice, DOJ, is the agency tasked with supervising, investigating, and providing assistance to parolees, pardonees, and probationers in the community. Once the Board of Pardons and Parole, BPP, grants parole or recommends conditional pardon, it is the PPA that carries out community supervision through its network of probation and parole officers nationwide. Why the others are wrong. A. BJMP. The BJMP operates jails and manages detainees, inmates. It does not have a community supervision function for released individuals. C. BPP. The Board of Pardons and Parole is the policy-making and quasi-judicial body that grants parole and recommends pardon. It does not handle the day-to-day supervision of parolees in the community. That is the PPA's job. D. BuCor. BuCor manages national prisons. Its jurisdiction ends when an inmate is legally released. It does not supervise released offenders in the community. Edge knowledge. BPP equals grants parole, PPA equals supervises parolees. These two agencies work together but have distinct roles. A common trap is confusing who grants versus who supervises. Remember, PPA is the supervisor on the ground. Question number 17. What is the term for a situation where an offender is released from prison and required to stay within a specific area, typically their hometown, as a condition of their release? A. Parole, B. Probation, C. Destierro, D. House arrest. Correct answer. A. Parole. Why A is correct. While parole conditions vary, one common condition is the requirement for parolees to reside within a designated area or report to a specific jurisdiction, typically their legal residence or hometown, and to report regularly to their assigned parole and probation officer, PPO. The geographical restriction placed on a parolee as part of their release conditions makes parole the most appropriate answer in this context, as it is the standard conditional release mechanism that includes residency and movement restrictions. Why the others are wrong. B. Probation. Probation also involves community supervision but is granted instead of serving a prison sentence. The question specifies release from prison, which points to parole rather than probation. Probationers generally were never imprisoned. C. Destierro. Destierro is a penalty under the RPC that prohibits the convict from entering a particular place, not residence restriction. It is imposed by the court as a sentence, not a post-incarceration condition. D. House arrest. House arrest is typically a judicial or executive restriction to one's residence. While some executive orders may impose this on high-profile detainees, it is not the standard term for the conditional release described in the question. Edge knowledge. Released from prison plus conditions, area restriction, equals parole. If the offender was never imprisoned and is supervised in community equals probation. The phrase released from prison is the key trigger. Question number 18. The concept that a prisoner retains all rights of a free citizen except those expressly taken away by law are necessarily implied in imprisonment is known as A. The medical model of corrections, B. The hands-off doctrine, C. the retained rights theory. D. The justice model. Correct answer. C. The retained rights theory. Why C is correct. The retained rights theory, also called the residual rights theory, holds that inmates retain all constitutional and civil rights except those specifically limited or removed by law or as a necessary consequence of imprisonment, e.g., freedom of movement is restricted, but rights to due process, access to courts, and protection from cruel treatment are retained. This theory forms the basis for modern prisoner rights litigation and is recognized in Philippine jurisprudence. Why the others are wrong. A medical model of corrections. This model treats crime as a social disease and the offender as a patient requiring diagnosis and treatment. It is a rehabilitative philosophy, not a theory about prisoner rights. B. Hands-off doctrine, the opposite of the retained rights theory. Under this doctrine, courts traditionally refused to interfere with prison administration decisions, treating inmates as having surrendered most of their rights. This doctrine has largely been abandoned in modern jurisprudence. D. Justice model. The justice model emphasizes fairness, proportionality, and accountability in punishment. It is a correctional philosophy, not specifically a theory about the rights retained by prisoners. Edge knowledge. Retains all rights except those expressly taken equals retained rights theory. The word retain in the question is the giveaway, associated directly with the retained rights theory. Question number 19. Under Republic Act No. 9344, Juvenile Justice and Welfare Act, what is the minimum age of criminal responsibility in the Philippines? A. 12 years old, B. 15 years old, C. 9 years old, D. 18 years old. Correct answer. B. 15 years old. Why B is correct. Under Republic Act No. 9344, as amended by RA 10630, a child 15 years old or below is exempt from criminal liability. Specifically, a child who is 15 years old or younger at the time of the commission of the offense shall be exempt from criminal liability and be subjected to an intervention program. A child who is above 15 but below the 18th of May be subject to diversion or, if they acted with discernment, may face criminal proceedings with the protection of the juvenile justice system. The minimum age of criminal responsibility, i.e., the age at which criminal liability begins, is above 15 years. Why the others are wrong. A. 12 years old, RA 11596, 2021, proposed raising the minimum age of criminal responsibility to 12 from 9, but under RA 9344, the primary law, children 15 and below are exempt. Note, there was legislative discussion but 15 remains the operative standard under RA 9344 as amended. Circa 9 years old, under the old revised penal code, before RA 9344, the minimum age of criminal responsibility was 9 years. RA 9344 raised this to 15. D. 18 years old. 18 is the threshold for being considered an adult in criminal proceedings, not the minimum age of criminal responsibility. Edge knowledge. RA 9344 equals 15 years old and below equals no criminal liability. Old RPC said 9 years old, but RA 9344 raised it to 15. If the question references RA 9344, the answer is 15. Question number 20. The Auburn system of prison discipline differed from the Philadelphia system primarily in that, A. The Auburn system required total solitary confinement 24 hours a day. B. The Auburn system allowed inmates to work together in silence during the day. C. The Auburn system focused entirely on religious penitence. D. The Auburn system prohibited all forms of labor inside the prison. Correct answer. B. The Auburn system allowed inmates to work together in silence during the day. Why B is correct. The Auburn system, congregate system, developed at Auburn Prison, New York, 1816 to 1820s, under Elam Lins, allowed prisoners to work together in groups during the day under strict silence, while being isolated in individual cells at night. The enforced silence was maintained by corporal punishment for violations. This contrasted sharply with the Philadelphia, separate, system's complete isolation at all times. Why the others are wrong. A total solitary confinement 24 hours a day. This describes the Philadelphia system, not the Auburn system. Complete isolation was the hallmark of the Pennsylvania, Philadelphia approach. C. Focused entirely on religious penitence. While religion played a role in both systems, especially Philadelphia, the Auburn system's primary focus was economic productivity through prison labor, not religious reform. The emphasis on silent work was partly to prevent inmate corruption and to maximize labor output. D. Prohibited all forms of labor, completely incorrect. The Auburn system is famous precisely for its organized group labor system. Prison labor and industrial productivity were central to the Auburn model. Edge knowledge. Auburn equals congregate equals silent group work by day plus solitary by night. The word silent is the key differentiator for Auburn. If you see silent labor, it's always Auburn. Question number 21. An inmate serving a sentence of 10 years has accumulated 3 years and 6 months of good conduct time allowance, GCTA. Which of the following correctly describes the effect of the GCTA? A. The inmate's conviction is erased from the records. B. The inmate's sentence is reduced by the accumulated GCTA, thus shortening the period of imprisonment. C. The inmate is automatically released upon accumulation of GCTA credits. D. The inmate's penalty is converted to a fine equal to the GCTA period. Correct answer. B. The inmate's sentence is reduced by the accumulated GCTA, thus shortening the period of imprisonment. Why B is correct. Under Republic Act No. 10592, GCTA law, which amended Articles 97 to 99 of the revised Penal Code, good conduct time allowance operates as a deduction from the period of imprisonment. The accumulated GCTA is subtracted from the maximum sentence, effectively shortening the time the inmate must serve in prison. In the given example, the inmate effectively needs to serve only 10 years minus 3.5 years equals approximately 6.5 years. It does not erase the conviction, convert the penalty, or cause automatic release by itself. Administrative processing is still required. Why the others are wrong. A conviction is erased. Only a pardon, absolute, or amnesty can erase the effects of a conviction. GCTA only reduces the imprisonment period, the conviction stands. C. Automatic release upon accumulation. GCTA reduces the sentence mathematically, but formal release requires administrative processing by the prison authority. There is no automatic release, documentation and clearance must be completed. D. Penalty converted to a fine. There is no legal provision converting imprisonment to a fine through GCTA. These are completely separate types of penalties under the RPC. Edge knowledge. GCTA equals deduction from imprisonment period. It shortens the time behind bars, nothing more, nothing less. No erasure of conviction, no fine conversion. Question number 22. Which of the following situations disqualifies an offender from applying for probation under PD 968, as amended? A. The offender is a first-time criminal. B. The offender is convicted of a crime and sentenced to 5 years imprisonment. C. The offender has previously been on probation. D. The offender is convicted of a crime punishable by a fine only. Correct answer. C. The offender has previously been on probation. Why C is correct. Under Section 9 of PD 968, Probation Law, the following are disqualified from probation. 1. Those sentenced to serve a maximum term of more than 6 years. 2. Those convicted of subversion, organized, syndicated crime, crimes against national security. 3. Those who have previously been on probation. 4. Those convicted of offenses under the Dangerous Drugs Act and similar laws, with some nuances. And 5. Those who filed an appeal, with amendments. Having previously been on probation is an absolute disqualifier. Probation is intended as a one-time opportunity for reform. Why the others are wrong. A first-time criminal. Being a first-time offender is actually a favorable factor for probation, not a disqualifier. The law is designed primarily for first-time, low-risk offenders. B. Sentenced to 5 years. A 5-year sentence is within the 6-year threshold for probation eligibility. This offender would not be disqualified based on sentence length alone, assuming no other disqualifying factors. D. Punishable by fine only. Offenders whose sentence involves only a fine, no imprisonment, are typically still eligible for probation or may not even need it. This is not a disqualifying circumstance under PD 968. Edge knowledge. Prior probation equals automatic disqualification. Probation is a one-time benefit. This is one of the most frequently tested disqualifiers. Memorize. Once on probation, no second probation. Question number 23. The mark system developed by Captain Alexander Maconochie in Norfolk Island rewarded prisoners with marks for a good behavior, labor, and study, which could be used to purchase food, privileges, or reduce their sentence. B. Informing prison authorities about other inmates' misbehavior. C. Completing religious instruction and attending daily prayers. D. Volunteering for dangerous prison work assignments. Correct answer. A good behavior, labor, and study, which could be used to purchase food, privileges, or reduce their sentence. YA is correct. Captain Alexander Maconochie, Superintendent of the British Penal Colony at Norfolk Island, 1840, introduced the revolutionary mark system, a token economy where prisoners earned marks for good conduct, hard work, and educational progress. These marks could be used to purchase food, clothing, and other privileges, and could also be accumulated to earn early release. This was a radical departure from purely punitive corrections and is considered one of the earliest forms of behavioral modification and earned privilege systems in penology. Why the others are wrong. B. Informing on other inmates. The mark system was about individual positive achievement, not informant systems. Encouraging snitching could create violence and distrust, antithetical to the rehabilitative spirit of Maconochie's system. C. Religious instruction and prayers. While religion was a component of 19th-century prison life, the mark system was specifically tied to measurable behavioral outputs, work, study, and conduct, not religious attendance. D. Volunteering for dangerous work. The mark system was about earning marks through constructive, structured activities. It was not a hazardous duty incentive program. Edge knowledge. Maconochie plus Norfolk Island plus marks for good conduct, work, study equals the mark system. This is a classic penology history question. Associate Maconochie with the mark system and Norfolk Island as the location. Question number 24. Which of the following correctly describes the concept of prisonization as introduced by Donald Clemmer? A. The process of building more prisons to accommodate the growing prisoner population. B. The adoption by inmates of the customs, norms, and culture of the prison society. C. The physical hardening of prison facilities to prevent escape. D. The transfer of inmates from local jails to national penitentiaries. Correct answer. B. The adoption by inmates of the customs, norms, and culture of the prison society. Why B is correct. Donald Clemmer introduced the concept of prisonization in his 1940 work, The Prison Community. He defined it as the process by which inmates absorb the informal culture, norms, values, language, argot, and criminal attitudes of the prison subculture. The longer an inmate remains incarcerated, the more prisonized they become, a process that undermines rehabilitation and increases the likelihood of reoffending upon release. Prisonization is considered one of the major obstacles to successful correctional rehabilitation. Why the others are wrong. A. Building more prisons. This describes prison expansion or infrastructure development. It has nothing to do with Clemmer's sociological concept. C. Physical hardening of prison facilities. This is related to prison security engineering, e.g., reinforced walls, surveillance systems. It has no connection to Clemmer's sociological concept. D. Transfer of inmates. This is a correctional administrative, logistical function called inmate transfer or classification. It is not related to the sociological process of prisonization. Edge knowledge. Prisonization equals inmates absorbing prison culture, argot, values, criminal norms. Key word, Donald Clemmer. Think of it as the opposite of rehabilitation. Prisonization makes re-entry harder. Question number 25. The Correctional Institution for Women, CIW, in Mandaluyong City is managed by which agency? A. Bureau of Jail Management and Penology, BJMP, B. Bureau of Corrections, BuCor, C. Department of Social Welfare and Development, DSWD, D. Philippine National Police, PNP. Correct answer. B. Bureau of Corrections, BuCor. Why B is correct. The Correctional Institution for Women, CIW, is one of the 7 operating units of the Bureau of Corrections, BuCor. Located in Mandaluyong City, it is the national penitentiary exclusively for female convicted offenders sentenced to more than 3 years of imprisonment. As a BuCor facility, it operates under the supervision of the Department of Justice, DOJ. The 7 BuCor facilities include NBP, CIW, Sablayan Prison and Penal Farm, Leyte Regional Prison, Davao Prison and Penal Farm, Iwahig Prison and Penal Farm, and San Ramon Prison and Penal Farm. Why the others are wrong. A. BJMP. BJMP manages city and municipal jails for short-term detainees and those sentenced to 3 years or less. The CIW is not under BJMP's jurisdiction. C. DSWD. DSWD handles child welfare, social services, and CICL programs. It does not manage adult correctional institutions like the CIW. DPNP. The PNP is a law enforcement agency. While it operates some lockup facilities for short-term detention, it does not manage national penitentiaries like the CIW. Edge knowledge. Memorize the 7 BuCor facilities. The CIW, Women's Prison, is always among the choices and is always under BuCor. A quick mnemonic. CIW is a national prison equals BuCor. Question number 26. Under the Bureau of Corrections Act of 2013, RA 10575, what is the authorized rank of the head of BuCor? A. Commissioner General, B. Superintendent General, C. Director General, D. Secretary General. Correct answer. C. Director General. Why C is correct. Under Republic Act No. 10575, Bureau of Corrections Act of 2013, the head of the Bureau of Corrections, BuCor, holds the rank and title of Director General. The Director General is appointed by the President of the Philippines upon the recommendation of the Secretary of Justice, and must be a member of the Philippine Bar or hold a master's degree, among other qualifications. This rank was a significant upgrade from the previous director designation, reflecting BuCor's enhanced mandate and organizational stature. Why the others are wrong. A Commissioner General. This rank is not used in BuCor. The Bureau of Immigration uses Commissioner, and the Bureau of Internal Revenue uses Commissioner, but BuCor uses Director General. B. Superintendent General. Superintendent is used for heads of individual prison facilities, e.g., NBP Superintendent, not for the national head of BuCor. D. Secretary General. Secretary General is commonly associated with international organizations, e.g., UN Secretary General, or the highest official of a legislative body. It is not used in the Philippine BuCor organizational structure. Edge knowledge. BuCor head equals Director General, under RA 10575. Don't confuse with Superintendent, Facility Head, or Commissioner. RA 10575 is the key law. Question number 27. Which theory of punishment is based on the principle that society has the right to protect itself from dangerous individuals, and therefore, keeping offenders incarcerated is justified even if they cannot be reformed? A. Reformative theory. B. Deterrence theory. C. Retributive theory. D. Incapacitation theory. Correct answer. D. Incapacitation theory. Why D is correct. The incapacitation theory, also called the theory of social protection or disablement, justifies punishment on the grounds that society must be protected from dangerous individuals, and the most effective way to achieve this is to physically remove them from the community, through imprisonment, exile, or in extreme cases, physical disablement. Unlike rehabilitation, incapacitation does not concern itself with changing the offender. Its sole focus is protecting society by neutralizing the threat. Why the others are wrong. A reformative theory, this theory holds that punishment should aim to reform and rehabilitate the offender, transforming them into a law-abiding citizen. The reform of the offender is central, the opposite focus from incapacitation. B. Deterrence theory. Deterrence aims to prevent future crime through the fear of punishment, both in the offender, specific, and in the public, general. It is forward-looking but focuses on behavioral change through fear, not on physical removal. C. Retributive theory. Retribution is about deserved punishment proportional to the crime, just deserts. It is backward-looking and focuses on justice for the past act, not on future protection through physical removal. Edge knowledge. Incapacitation equals remove from society equals social protection. The key phrase in any question pointing to this theory is protect society or prevent crime by removing the offender. Physical neutralization equals incapacitation. Question number 28. Which of the following is not a characteristic of a total institution as described by sociologist Irving Goffman in the context of prisons? A. All aspects of life are conducted in the same place and under the same authority. B. Inmates are treated as individuals with full autonomy and freedom of choice. C. Activities are conducted in the company of a large batch of others treated alike. D. A single rational plan exists ostensibly designed to fulfill the official aims of the institution. Correct answer. B. Inmates are treated as individuals with full autonomy and freedom of choice. Why B is correct. Irving Goffman, in his seminal work Asylums, 1961, described a total institution as a place where individuals live a fully enclosed, formally administered life. The key characteristics include 1. All activities under one roof, authority. 2. Activities done in the company of others. 3. Rigid scheduling. 4. A single overarching rational plan. Notably, the opposite of autonomy is true in total institutions. Inmates are stripped of their individuality and personal identity through processes like uniform clothing, de-individuation, and loss of personal freedom. The concept of mortification of the self describes how the institution systematically removes inmates' sense of personal autonomy. Why the others are wrong. A. All aspects of life under the same authority. This is a defining characteristic of a total institution. In a prison, eating, sleeping, working, and recreation all occur under the authority of the prison administration. C. Activities with a large batch treated alike. Goffman specifically noted that inmates are treated as a homogeneous batch rather than as individuals, another core characteristic of total institutions. D. A single rational plan to fulfill official aims. Goffman's total institution model includes the characteristic that the entire daily regime is organized around the stated institutional goal, e.g., punishment, rehabilitation, whether or not it actually achieves it. Edge knowledge. Not a characteristic plus autonomy, freedom equals correct answer. In Goffman's total institution, individual autonomy is destroyed, not preserved. The word autonomy in prison context should trigger the answer. Question number 29. Inmate Juan is a national prisoner serving a 15-year sentence. He has served 8 years and has been consistently well behaved. His case is being considered for early release by the Board of Pardons and Parole. Which stage of the process must the board evaluate to determine if Juan has served the minimum of his indeterminate sentence? A. The minimum period of his indeterminate sentence as fixed by the trial court. B. The total period of his sentence, 15 years, c. 1/2 of his sentence. D. 1/3 of his sentence. Correct answer. A. The minimum period of his indeterminate sentence as fixed by the trial court. Why A is correct. Under the Indeterminate Sentence Law, Act No. 4103, a prisoner sentenced to an indeterminate sentence, with a minimum and maximum period, becomes eligible for parole when they have served the minimum period of their sentence as determined by the sentencing court. The Board of Pardons and Parole evaluates whether the prisoner has served the minimum penalty, exhibits good behavior, and is fit for reintegration. The minimum period, not a fraction of the total, is the legal threshold for parole eligibility under the ISL. Why the others are wrong. B. Total period of 15 years. This would mean one must serve his entire maximum sentence before being eligible, which negates the very purpose of parole and the Indeterminate Sentence Law. C. 1/2 of his sentence. The 1/2 fraction is not the legal standard under the ISL. This might be confused with provisions under special laws or GCTA calculations, but it is not the ISL threshold for parole eligibility. D. 1/3 of his sentence. Similar to the above, a 1/3 fraction is not the ISL standard. These fractional thresholds are common distractors but have no direct basis in Act No. 4103. Edge knowledge. ISL plus parole eligibility equals must serve the minimum period set by the court. The court sets both a minimum and a maximum. The prisoner can be paroled after the minimum. Don't fall for the fraction distractors. Question number 30. The Irish system of graduated prison discipline, also known as the progressive stage system, was developed by A. Alexander Maconochie, B. Walter Crofton, C. Zebulon Brockway, D. Elam Linds. Correct answer. B. Walter Crofton. Why B is correct. Sir Walter Crofton of Ireland developed the Irish system, progressive stage system, in the 1850s, building upon Maconochie's Mark system. Under the Irish system, prisoners progressed through 4 stages. 1. Solitary confinement on reduced diet. 2. Associated labor in silence. Auburn-like. 3. Intermediate stage with increased freedom and work outside prison, resembling probation. And 4. Ticket of leave, conditional release, an early form of parole. The Irish system is recognized as the direct precursor to modern parole. Crofton is often called the father of parole in criminology history. Why the others are wrong. A. Alexander Maconochie. Maconochie developed the Mark system at Norfolk Island, which was the inspiration for the Irish system. While his work preceded and influenced Crofton, he did not develop the Irish system itself. C. Zebulon Brockway. Brockway is credited with developing the reformatory system at the Elmira Reformatory in New York, 1876, which was influenced by the Irish system. He is associated with indeterminate sentences and vocational training in the U.S. context. D. Elam Linds. Linds was the warden who established the Auburn system of congregate silent labor. He is associated with strict discipline and corporal punishment in early American prisons, not the Irish progressive stage system. Edge knowledge. Crofton equals Irish system equals progressive stage equals 4 stages ending in ticket of leave. Create a memory chain. Irish equals Crofton equals 4 stages equals early parole. This is one of the most tested penology history items in the CLE board exam.
If this video gave you an edge, sharpen that like button and subscribe to stay ahead.